My name is Carl Failmaster. I've been a licensed Virginia attorney since 1992 after I graduated from William & Mary Law School. My main focus has been on inexpensive estate planning. This video today will describe the four main documents that most people need, why they need them, and when they need them. First of all, we're going to start with a person's status. During your lifetime, if you are in good health and have full mental capacity, you are perfectly able to have full control of your own person and your own property. However, we do not have a future crystal ball and know the future. Therefore, we do not know if someone will become disabled or lose their mental capacity. If that happens, you need to have planned in advance. And they do so, first of all, with an advanced medical directive. Advanced medical directive will take care of a person's person during their lifetime in the event of their incapacity. An advanced medical directive has two portions. The first portion is a living will. That portion of the document is one in which a person makes a decision in advance regarding life support machines, what conditions they might be under, or if they will not be having life support machines on them at all. It's better for you to make that decision yourself rather than to burden your family with that decision later. The second portion of an advanced medical directive is a medical power of attorney. A medical power of attorney appoints another individual or an alternate individual to make your medical decisions in the event that you are unable to make them. This is especially important in terms of changing the medical facilities or the medical care provider in the event that you're receiving poor quality treatment. It also is important in the event that a person has a stroke. A doctor needs to make this decision right away as to whether or not they need to give certain medicine. If you've got this medical decision and the power of attorney appointed, well, then you're in good shape. Otherwise, you could have some problems. Secondly, a person's property. If you become disabled or lack mental capacity, a durable power of attorney is the document that you will need, and that will allow someone else to handle your finances in the event that you're unable to do so. We generally recommend that these be a general power of attorney with broad powers. This person who you appoint as your power of attorney, however, must be someone in whom you have a high degree of trust. The person must also be honest and financially responsible. Now, just as sure as taxes are in this lifetime, death also often happens to all of us. And at that point in time, everyone should have a last will and testament. This document does several things. First of all, in terms of your person, it makes funeral or burial decisions. If you have left behind minor children, it will appoint a guardian to represent those children and to handle those children after your lifetime. Secondly, in terms of your property, it allows for the executor to go ahead and make a distribution of your estate to your intended beneficiaries. Now, let's just talk about a couple things here with a will. There are certain techniques in which you can avoid probate with a will, such as having all of the beneficiaries and the executors be an exact match. If they are, the executors are allowed to sign a statement in lieu of an accounting and skip the probate process. Another thing that we would like to avoid in the will is avoid the surety on the bond. This will save 1% to 2% of your assets. For this to occur, the bond must be waived, or the surety must be waived, and the executor, or at least one of them, must be a Virginia resident. Now let's look at a trust. A lot of people ask us, they say, what is a trust? I don't understand. What does that mean? Do I need a trust and a will? All these kinds of questions are things that we hear. The thing about a trust is it's a legal document or an agreement between yourself as grantor and yourself as trustee. But you should think of it almost as a safe that will pass through time and will outlive you. In this safe, you may put all of your possessions. As a matter of fact, I recommend that you put all your possessions in there. So you're the original grantors. Sometimes this person's also called the settlor or the trust maker. You make the safe, and then you put everything into it. And when we say you put everything into it, what we really mean is that you transfer your assets from yourselves as individuals to yourselves as trustee. And so while you have full mental capacity, you alone, as the trustee, hold the keys to the safe or the combination to the safe and have full control of those assets. you have the ability to revoke that trust. You can change it or amend it, whatever you wish to do during your lifetime, as long as you're mentally able. Now, if there comes a point in time when you lose capacity, you're disabled, you're mentally incapacitated, something like that, your successor trustee, who's a person who you've appointed in this trust, will then take over and manage your assets for yourselves during your lifetime. During your lifetime, you are the primary beneficiaries. You are the only people who have any rights to these assets. No one else has anything in them at all. Okay? But afterwards, the successor trustee, if you're unable, he manages them during your lifetime for you. And then when anyone passes away, your trust has left instructions for that successor trustee to pass on your assets to the beneficiaries. Now, while a trust is a little bit more complicated to set up and it's a little bit more expensive, in doing so, it is always the best method for handling an estate. Number one, it always avoids the probate process. It avoids the probate tax. It also avoids any surety on a bond. Okay, and it's also a very flexible document which allows you to do almost anything you wish to with your assets. So that basically summarizes the 4 documents that I think most people should have: an advanced medical directive, a durable power of attorney, a last will and testament, and a trust. We would also point out that in doing this for the last 26 years, I always do revisions of my own documents free of charge, regardless of the reason. If you change your mind, or if your situation changes, you realize I've misspelled somebody's name or something, we make all revisions free of charge. Another important fact to think about is that we only collect our fee after you are 100% satisfied with those documents. Thank you.